Tennessee state constitution requires that districts for both the state Senate and House of Representatives be redrawn on the basis of population after the U.S. Census is conducted every 10 years. Despite the state's constitutional requirement that districts be reapportioned every 10 years, however, by 1960, this process had not been done in Tennessee since 1901 and the 1900 census. The result was that by 1960, the state's legislative districts varied in population from just a few thousand people in some districts to tens and even hundreds of thousands in others.
Members of the legislature, whether they be the state legislature or Congress, have an interest in a certain stability in who their voters are. Reapportionment, when districts are redrawn, is uncomfortable, unpleasant for the members of the legislature who are to do the very redistricting themselves. What frequently happened in legislative bodies was the legislators would look at each other and say, I tell you what, you keep your seat, I'll keep my seat, we'll keep the districts the way they are. These are the district lines that got us elected in the first place. Everybody plays, everybody wins. But without reapportionment, the increasingly depopulated rural areas still have that one seat, and the increasingly densely populated urban areas still only have one representative in the legislature. And the effect is arguably unjust, unfair, and even unconstitutional to the voters in urban areas.
And that's what happened essentially in the after World War II. And after World War I, we became a more cityfied urban place, and everybody moved to the cities. But the districts from which representatives in the state government were elected and the federal government didn't change. Let's say that everybody moved out of a certain district and the only person left there was Farmer Jones. That would mean that Farmer Jones had his own representative, whereas everybody who moved to a city, and there could be millions of those, would still have the same number of representatives they had when there was nobody living in the city. So that's why reapportionment's important. It's to make sure we follow the population trends and where people are living so that there's a fair representation by population.
Mr. Charles Baker, a resident of Shelby County, Tennessee, complained about the state's failure to apportion the state House and Senate districts. Mr. Baker demonstrated that Shelby County had almost 10 times as many residents as some of the neighboring rural districts. Mr. Baker argued that because districts had not been apportioned since 1901, the votes of citizens living in urban areas were representationally worth less than the votes of citizens living in less populated rural communities. Mr. Baker was joined by the mayor of Nashville, a county judge, and several other citizens of urban areas in arguing that this variance caused residents in urban areas to fail to receive the equal protection of the laws as required by the 14th Amendment to the U.S. Constitution. Together, they filed a lawsuit in U.S. District Court against Tennessee's Secretary of State, Joe Carr, seeking to have the 1901 apportionment law declared unconstitutional.
The district court dismissed the case based on precedent. Supreme Court precedent, Colgrove versus Green, had held that these cases are not justiciable. Judges can't properly decide what fair district lines look like, and the federal courts are not going to get in the business of issuing orders to state governments to redraw district lines.
The Colgrove versus Green case was on the book saying judges should not be involved in making these kinds of decisions. They should restrain themselves from becoming involved in the political system because that would do harm to our separation of powers, where the judges handle the law and the governor or the executive and the legislative branch handle the politics. And we can't have judges involved because then we become a nation of judges rather than a nation with separation of powers.
Having lost in U.S. District Court, the plaintiffs appealed their case to the Supreme Court of the United States, and in 1961, the court agreed to hear the case. In the case of Baker versus Carr, the court was faced with the task of answering whether or not the 14th Amendment's Equal Protection of the Law Clause gave federal courts jurisdiction to hear cases involving the drawing of legislative districts.
Well, of course, the argument for Tennessee was Colgrove was a good decision, stand by it. It's good law. It's exactly what courts should follow, their own restraint. And that was a very simple argument on their part. The plaintiffs made a very persuasive case. They said, we'll never get reapportionment because the people who are in the state legislators in office, are the ones who have to vote for reapportionment. And those who represent those special interests, they're not going to vote against their own special interests. That's what keeps them in office. So because of the politics, there's no way for the people to come to vote to change it. So that's not going to happen. For example, if we even wanted to have a statewide referendum, we'd have to get that cleared by the legislature to begin with in Tennessee. And that's not going to get cleared. So we have no way to fix it. And the people who are refusing to fix it will not change their minds because they'll give up political power if they fix it.
In the spring of 1962, Justice Charles Whitaker retired from the court, leaving only 8 justices to make a ruling. Finally, in 1962, in a split decision, the court ruled 6-2 in favor of the plaintiffs, ruling that federal courts do have jurisdiction to hear cases involving the drawing of legislative districts. Writing for the majority, Justice William Brennan explained the majority's decision.
The district court misinterpreted Colgrove versus Green and other decisions of this court on which it relied. Appellants claim that their being denied equal protection is justiciable, and if discrimination is sufficiently shown, the right to relief under the Equal Protection Clause is not diminished by the fact that the discrimination relates to political rights. We conclude that the complaint's allegations of a denial of equal protection present a justiciable constitutional cause of action upon which appellants are entitled to a trial and a decision. The right asserted is within the reach of judicial protection under the 14th Amendment.
Justice Tom Clark, in his concurring opinion, compared Tennessee's apportionment picture to a crazy quilt with no rational basis. He then said that the plaintiffs had no way of challenging the discrimination in voting strength and that the only road open to them was through the courts.
As John Rutledge said 175 years ago in the course of the Constitutional Convention, the chief function of the court is to secure the national rights. It is well for this court to practice self-restraint and discipline in constitutional adjudication. But never in its history have those principles received sanction where the national rights of so many have been so clearly infringed for so long a time.
You have to understand that this is serious business that is at play in Baker versus Carr because of the issue of separation of powers and the issue that we don't want to be a nation run by judges. It's also serious business because we don't want to be a nation in which people do not have their vote count as much or be worth as much as someone else's. So we have 2 very important philosophical issues at play here. And the result was that we have dissenting votes.
Because he had written the opinion of the court in Colgrove versus Green, Justice Felix Frankfurter felt strongly about its repudiation and thus dissented, along with Justice John Marshall Harlan II. A proponent of judicial restraint, Justice Frankfurter warned of the damage the court might bring upon itself by engaging in political matters and urged
a frank acknowledgement that there is not under our Constitution a judicial remedy for every political mischief, for every undesirable exercise of legislative power.
Justice John Marshall Harlan II wrote his own dissenting opinion. He said,
I can find nothing in the Equal Protection Clause or elsewhere in the federal Constitution which expressly or impliedly supports the view that state legislatures must be so structured as to reflect with approximate equality the voice of every voter. Not only is that proposition refuted by history, but it strikes deep into the heart of our federal system.
It was difficult to say that there was no problem with what was going on in Tennessee. Not only were they violating their state constitution, but these districts were so grossly disproportionate. It was such an inequality in giving so much more political power to rural voters than urban voters that it was unjust. But Justice Frankfurter said, this injustice is not something that has a federal judicial remedy. Our Constitution doesn't give any clear rules, and even if it's unconstitutional, not every violation of the Constitution has a federal judicial remedy. This is one of those cases, he said, that should be left to the political branches, the state legislatures, Congress, or constitutional amendment to remedy. But nonetheless, the majority held, and this holding has not been overturned, that in fact the federal courts will supervise the drawing of district lines in order to assure a certain degree of equality between the districts as to the number of inhabitants.
Now, some will say that we are suffering from the result. Now, one reason we have such a divided government is that every 10 years, whoever's in power in a state government draws the districts to protect the party that's in power, to make sure that the districts are drawn in such a way that it'll favor their party. And you can do that by population. You can still have a population that's in control. You just draw these weird-shaped districts that you think of a district should be like square, but oh no, they're drawing them so that this district becomes a Republican district and this district becomes a Democratic district. And the result is that we now have safe districts rather than districts in which people really have to contend for the vote, which means people get voted back in power again and again and again.
Just as it had done in the case of Mapp versus Ohio, the U.S. Supreme Court shifted away from earlier precedent with its decision in Baker versus Carr. The ruling provided an avenue for the federal courts to play a role in the redrawing of those legislative districts where voters claimed their votes were underrepresented. Over the next 10 years, several more lawsuits were filed, and over time, the political map of the entire nation was changed. The late Chief Justice Earl Warren called Baker versus Carr the most important case the court decided in his 16 years as Chief Justice. 2 years later, in 1964, the court, after waiting unsuccessfully for the states to act on their own, handed down what are called its one-man, one-vote decisions in Westbury versus Sanders and Reynolds versus Sims. In Westbury, the court ruled that U.S. House districts must be approximately equal in population. In Reynolds versus Sims, the court ruled that districts for both houses of a state legislature must be approximately equal in population.